Good morning, all. This application hearing is in the matter of CFI 031-2017 and is being held by way of video conference before Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Onoma. Lead counsel is Mr. Faisal Osman. The defendant is represented by Baker and McKenzie, and lead counsel is Hugh Lands. Thank you, Your Honour.
All right. Well, thank you, Mr. Osman.
Yes, thank you, Your Honour. I, for the applicant claimant in this matter, Mr. Lyons for the bank. Before I go any further, I just wanted to check that all of the material that you've got. And so you should have a hearing bundle, which is 404 pages.
Let me see. Yes, I do. 404.
Thank you. Thank you. There is also written submissions with my name, so you should have that as well. My learned friend, Mr. Lyons, has also put in written submissions. You should have that as well.
Yes.
And I think late last night or early this morning, Mr. Lyons will forgive me, there were a couple of authorities that he had also sent, and you should have those as well.
Yes.
Well, that's good news. It looks like you have everything, which is always very pleasing to hear. Your Honour, can I just spend a few minutes introducing what this claim is? Because it has a long history. And perhaps the best way to do that is attached to the back of my skeleton argument is a chronology. And can I ask you to kindly turn to that chronology, please?
Yes, I'm going to have to see where I have read it, but I now have to find it. Just bear with me for a minute.
Of course.
I'm sorry, Mr. Osman, we've recently upgraded the system and I'm having some teething pains in negotiating it. But if you bear with me a couple of minutes, I think I should get there.
I don't know if it's good news or bad news, but we've all shared those teething pains. Just to clarify, it's not a separate document. It is attached to the back of the skeleton.
Yes, I'm still finding your skeleton at the moment.
Understood. Understood.
And sadly, I'm looking at a revolving wheel, but I think we've all become accustomed to.
Now. The revolving wheel.
Yes.
At the risk of interrupting, Your Honour, I think that Mr. Osman's instructing solicitor was struggling to file the skeleton on the system. So if your lordship is looking on the court system,
no, I do have it. I do have it. Thank you for your help, but yes, I do have it, and I have the chronology which is attached.
Thank you. And can I ask you, now you have it, if you kindly just turn to the chronology, which is, it's page 14 of the skeleton argument. I just wanted to give you an overview of, I think can be properly described as a case that's been going on for a while. You'll see the first entry is the first material event is in 2014. And that's when the personal guarantee, which I will take you to in a moment, which is the key aspect of this cornerstone, that's when it was allegedly executed. In regards to what happened before this court, 2017, so the 29th of June 2017, it's about a third of the way down in the chronology.
I have it.
That is when, and I'm going to use his first name, that's when Kian filed his Part 8 application, this application for declaratory relief. So that was back in 2017. As Your Honour has no doubt realised, as reading through the papers, the skeleton arguments and the witness statements, what happened in this case is that essentially, for want of a better term, it bifurcated. When the Part 8 application was lodged, there was then a defence, which I will take you to in a moment, which was lodged in reply. And quite early on in the process, there was an application for a request for inspection of two things. First, the personal guarantee itself. Secondly, inspection related to the witness to Kian's signature on the personal guarantee, a man called Zishan Mahmood. But concentrating on the inspection request for the personal guarantee first, the reason it was requested is because a handwriting expert needed to see the original. And that, I'll take you to that correspondence in a moment. That was the basis for the request. The personal guarantee had left the jurisdiction and had made its way to Kuwait. And that's when effectively the matter bifurcates, because what took place then, as you can see from the chronology, is that the bank went to Kuwait and looked to execute the personal guarantee and enforce it. The reason why it went to Kuwait is because Kian was at that time resident in Kuwait. And as you can see, as you go down the chronology, that case, the bank's case, worked its way through the Kuwaiti judicial system. First instance, at that point, personal guarantees, upon the bank's request, were analysed by a panel of 3 experts appointed by the court. Those experts came back with the opinion that the guarantee had been forged, rather the signatures were not Kian's. The bank appealed that to the Court of Appeal in Kuwait, did not succeed. The bank appealed that to the Court of Cassation in Kuwait and did not succeed. So after this claim had been issued for declaratory relief back in 2017, the reason why here we are in 2024, is because of that parallel set of proceedings, parallel in the sense that the bank issued the proceedings to enforce, that went all the way through the Kuwaiti system. And just as a highlight, why we are back here today is that after that final determination by the Court of Cassation in Kuwait, Mr. Federigoli wrote to the bank and said, now that you have exhausted all appeal rights in Kuwait and every level of the Kuwaiti judicial process has confirmed that the personal guarantee Kian signatures upon them are forged, do you accept that the guarantees are forged? There was some difficulty in getting a response. Several months went past. The bank didn't engage. Don't criticize Mr. Lyons for that. It just didn't. And then Mr. Federigoli, in order to move the matter on here before this court, issued the current application to lift the stay that was previously put in place in order for the bank to make its efforts to get the personal guarantee so it could be retrieved and handed over to the handwriting experts here. So that is a sketch, if I could put it that way, of the chronology. But I thought it was important to set out the material dates in one ready-to-see table to tie it all together. Otherwise, there might be questions asked as to why a claim issued in 2017 is finally finding its way before you in the latter half of 2024. That chronology and my high-level explanation is the reason why. Can I turn to the PG, because that's the document that matters in this case? You will find that in the hearing bundle. If we could turn to that, page 37.
Yes, I have that.
Thank you. I've actually taken you to the signature page because that's the that's the page that matters. And you can see two things. First of all, a signature under the name Kian Saadat Yazdi, and then next to it, that's the name Zishan Mahmoud, who is the reported, he verified the signature. I said earlier that the inspection request at the very beginning, which I'll take you to in a moment, had two elements. The first is, may we have the originals of the guarantees? The second is, who's Zishan Mahmoud? So that's where that comes from. Can I just take you also to page 51, which is not the personal guarantee, but it's interesting. So if I could ask you to turn to that.
Yes, I have that.
This document is is an additional aspect of the lending facility. It is the credit facilities agreement. Kian doesn't sign this document. I've taken you to the signature box at the end of it. The reason I wanted to show is that this is an indication of the surprising lack of, well, one can see from itself. If you look at the borrower's box there, it has a signature. It's not Kian, doesn't have a name, and it has the stamp from Pacific Controls LLC, which is the company that took out this lending, and another verified signature, someone called Altaf. I can't read the surname, but I raise it because it does appear that these documents were, how shall I say, compiled in a rather surprisingly cursory fashion. This one doesn't even have the name of the person who's signing for Pacific Controls. So one can get a sense of the rudimentary way in which this transaction was done. Be that as it may, on the first PG document, which is the one that matters, Kian's name appears, and Zishan Mahmoud's name appears as the verifier of that signature. So that is that's the PG. That's what is central in this case. That's what we say we had nothing to do with, had been forged. That is the very document that the bank took to Q8 to ask to be enforced. And the expert panel that had been appointed by the Q80 first instance court had agreed and had found that it was forged. And in fact, there was another process when the matter went up to the Court of Appeal, where another panel verified the first instance panel's finding and also agreed as well. So every single instance where this has been checked, it has been found to be a forged document. When I say this, I mean the personal guarantee. Can I briefly, I won't take you to them, but I will just mention them. The three judgments that I've spoken about, the commercial court judgment in Kuwait at first instance, the Court of Appeal judgment, and the Court of Cassation judgment, the originals have been provided in the hearing bundle. I don't know if you want to speak Arabic, but if you did, they can be read.
They're of no use to me, I'm afraid.
The translations are there as well. As there are varying qualities of translations when it comes to translating Arabic into English. I'm sure your lordship's experienced that already.
Yes.
In your time sitting.
Yes, I'm afraid I'm afraid we have that with statutory instruments.
Yes, it's a considerable part of my practice. But it is what it is. The translations are there. The first instance translation is of good quality. The Court of Appeal takes some time to understand. The Court of Cassation translation is good. The point is this: there's no disagreement about this. There's no disagreement. I'm sure Mr. Lyons will correct me. That the first instance court and the Court of Appeal and the Court of Cassation all decided against the bank. That's the process. But the judgments, if you needed to see them, are at page 184, 189, and 190. I won't take you to them because I don't think that matter is in dispute. Indeed, what happened in Kuwait. What I will take you to, please, is page 79 of the bundle. This is, I would do if I type the number properly. This is the bank's defense. When you have it, please let me know.
Yes, I have it.
Thank you. A note, Mr. Lyons' firm, Baker & McKenzie, they were not the original firm on record for the bank. This is why you see a different name on this defence. Mr. Lyons' firm took over, I think, sometime. I've got the date precisely, but not for a while. So the defence was lodged in back in 2017, November 2017. This is still the defence. It's not. There's been no application to amend. It's the only defence that the bank has made in these proceedings, and it's the defence that stands. Can I take you to a couple of paragraphs? The first, over at page 81, there are, what can I describe in this way? What look like recitals: A, B, C, D, and E. Can I take you to C, please? The defendant asserts that the personal guarantee was in fact executed by the claimant, Kian, therefore, this is the defendant, seeks a declaratory judgment holding that the personal guarantee is authentic and binding as between the parties. So that's the position, the bank's position square in the summary recital at the beginning of paragraph D. Just to pick up a couple of other instances, paragraph 2 in the defence, it's admitted that the claimant and defendant entered into a binding personal guarantee dated the 10th of December 2024. It's denied that the personal guarantee was signed by another person using the client's name as signature and therefore not void ab initio as a binding instrument. There are other instances where the bank puts its case squarely within the defence, and I'll just read them without necessarily taking to every one. But at paragraph D, 2D, the claimant is acting in bad faith. Kian is acting in bad faith, and he's seeking to rely on what seems to be fabricated allegations of forgery in order to avoid the performance of his obligations pursuant to the terms of the personal guarantee. And then there are other instances later on, in particular paragraph 18 and 20 and 22, where again the bank says quite squarely the signature of the claimant is not a forgery. And in further asserting that the signature is a forgery, the claimant is making unsubstantiated and unsupported allegations of certain material factual elements. The defendant note says Zishan Mahmood is no longer an employee of the defendant. I'll come back to that in a moment. Paragraph 22, the claimant did in fact execute the personal guarantee and is making unsubstantiated and unsupported claims with respect of Zishan Mahmood, who is the verifier. Right to the end. Page 89, the relief that the bank requests, threefold: reject the claimant's claim for declaration, for the court to issue a declaratory judgment holding the personal guarantees authentic and binding. So there's a cross application without a counterclaim being issued. So that's the relief requested, and any other further relief as well. I put that to you in terms of showing you what that defense is, because it's absolutely clear that the bank at that stage was saying whatever Kian is saying about these personal guarantees are untrue. They are authentic. And not only are they authentic, but we want the court to declare that they are authentic. So there's no doubt about it. This is what the bank is saying. This is the bank's case. These are authentic signatures on the guarantee. You will note the date of this defense is 2017. Tracking back to what I said earlier, this was before the first instance decision in, no, forgive me, that's not right. This is at the time the matter was being heard in Q8. So this was November 2017. 29th November 2017, that's the date of the defense. 10 days earlier, on the 19th of November 2017, that is when the Q80 Commercial Court made its decision, handed down its decision, applying the panel of experts' findings that the signatures were forged. The point is this, that defense makes no reference to what happened in the Commercial Court in Dubai. And so it was pleading out that Kian was not telling the truth without informing the court in its defense that in fact the Commercial Court in Dubai, in Kuwait, where the bank had taken the PG, the personal guarantee, to enforce, had found by way of the panel of experts that the personal guarantee was forged. So that doesn't appear anywhere in the defense. And this is part of the issue. The bank in Dubai is saying one thing, the bank in Kuwait litigating is finding themselves facing a completely different fate whatsoever. The two don't appear to be tying up. Moving forward from there, based on what was said in the defense, Mr. Fedrigoli for Kian writes a letter, and that is at page 91 of the hearing bundle. Can I take you to that, please?
I have it.
It's an email. So the headers at the top to the registry and to the bank's counsel, Jade. And this is the 4th of December 2017. So 5 days after the bank lodges its defense. And the key paragraphs in this email by Mr. Fedrigoli are towards the end of the first page, starting, the claimant intends to apply for an order that the defendant produces the originals of the question documents, the PGs, so the question documents can be inspected and examined by the two following experts. And he gives the name of the experts. One is Dr. Albar, and the second is Dr. Robert Radley. I accept, I'm about to give evidence. Those are two very eminent handwriting experts. Dr. Albar is a highly eminent practitioner, handwriting expert in the UAE, and Dr. Radley, the same in the United Kingdom. That is the reason this email is the inspection request for those personal guarantees, the originals. That is why the inspection request was made. There's also questions and inspection request in relation to Zishan Mahmood, but that is why the inspection request was made. So what Kian was asking to do is for the experts to look at the original. And that's what this is all about. A slight footnote. Dr. Albar has produced a witness statement in the proceedings, which is attached to the original Parte application. What's that about? The curiosity with partes in this jurisdiction is that when you issue the claim, you have to attach your evidence. So there's a slight ambiguity. What Mr. Fedrigoli did in respect, I think, is sensible. He issued a witness statement from Dr. Albar saying, I've looked at the copies, i.e. that which was served on Kian to say this is what we're going to enforce. But the expert report that he was seeking to put forward as evidence, that require the originals. And that's why he makes the inspection requests in the way that he does. So at this point, we don't have the originals. The bank has them, they're in QA. That's the basis for the inspection request. And the reason why the stay was imposed was to allow those documents to be obtained. There is what follows.
Mr. Osman, you said the bank had them. Did the bank have them?
The court. I'm sorry. You're absolutely right. Sorry about that. Sorry, Mr. Lyons. You're absolutely correct. Thank you for correcting me. The court had them. They worked their way up through the court system. At one point, the experts that the court had appointed, which the bank requested experts to be appointed by the court and to look at the signatures. Those reports are in the bundle. So can I take you to page 194? Yeah, 194, please, of the bundle.
Yes.
So this is a translation, arguably one of the better ones. This is a translation of what the experts had reported back to the court. Now, I dare say Your Honour is familiar with how proceedings work in the Gulf. Kuwait and Dubai are not dissimilar. What effectively happens is the petitioner goes to court, and it's very much the case. In fact, it happens almost all the time that the court pauses the proceedings and then appoints experts and asks the experts to report and then come back. So it's different than the proceedings that we're used to in the common law world, where the parties adduce expert opinion for the court to receive as evidence for the termination of the case. The process, forgive me if I'm telling you something you know very well.
I've come across this before, Mr. Osman.
Yeah, so it took me a little while to get my head around it, but it's effectively parties go, here is the complaint, what do you say, here is what we say, okay, we're going to pause. We, the court, not the parties, we, the court, will find the experts to come back and opine, and depending on what the experts say, we'll receive that and we'll continue onwards. So that's pretty much what happened in this case, and that's an important fact. The experts in this case that looked to the personal guarantee, which the bank asked the court to do as well. So the bank invited the court to do this, the court of first instance. The experts were eminent from the criminal laboratory in Kuwait. They were appointed by the court, a panel of 3, to check the personal guarantees. And the process is very similar to, no doubt, what Your Honour has seen before in other cases. Certainly I've seen in my jurisdiction, I dare say my learned friends have seen as well. The individuals are asked to attend, give handwriting samples, it's compared, there's a science behind it, they sit in a controlled environment, and those samples are taken. And then in minute detail, the experts study the 2 samples, compare them to the guarantees, etc. So this is an absolutely verified process done by experts from the criminal laboratory in Kuwait, not appointed by the claimant, not appointed by the bank, appointed by the court, and this is their finding. So the summary of it is, as one can see at page 195, the result. Based on the foregoing, we decided the following: both signatures attributed to Hassan, that's Mr. Yazdi's father, written on the personal guarantees dated, subject to examination, are different from signatures on the papers of his handwriting done by the department on 2/7/2017. Handwriting done by us in the department is that controlled environment test. So that is the result, and you can see paragraph 2, which follows. There is, if one flicks on just a couple more pages at page 198, later on, there is a verification of that by the General Department of Criminal Evidence Department of Forgery, grand title, but that's who they are. And that is a verification of what the experts I've just taken you to have done. So there's a 3-panel experts and sort of double belt and braces, double check. So that is the evidence, that is the expert opinion that went before the court of first instance. So the personal guarantee was analysed with that in mind. That exercise has been done, and then the court, the commercial court, rejected the bank's claim for enforcement. Bank appealed, and bank appealed again to the Court of Cassation. The reason why this is critical Well, perhaps the first reason is obvious. It's been checked and it's a forgery. But for today's purposes, the reason why now the stay is to be lifted is because the intention to have those originals received and analysed by Dr. Albar for the defendant, which the defendant was asking for an opinion from in Dubai, and Dr. Radley as well, that's fallen away because the originals have been checked and verified by eminent court-appointed experts in Kuwait. So my learned friend in his skeleton argument asks the question that or poses the point. Well, the defense haven't, the applicant hasn't explained why the stay needs to be lifted. There's a simple answer to that. They've been checked now. So the request that Mr. Fedrigoli made back in 2018 is no longer relevant. They have been checked, and we can continue. So when it comes to this court and seeking a declaration before this court, what would we be doing? We'd say the personal guarantees have been checked by experts and they're found to be forged. May we have a declaration, please, using that evidence? The case, therefore, the case here has narrowed since it was first issued. Now all we're saying is, look what happened in Kuwait. Look at what has been done in terms of the signatures being checked. That is the evidence. The declaration that we asked for is to say, for this court, may we have that declaration that as per that evidence, these signatures are forged. So that's the stay element. Why are we asking for the stay to be lifted? Because the conditions of the stay, and I've set this out in my written argument, don't exist anymore. They don't exist anymore. So there's no reason to continue the stay. My learned friend has a different view about that, which I'll come to in a moment. But that is the premise of the application that we're making. No need for the stay. It's been checked. Wasn't checked when we asked for it. Been checked now. So that's the reason why there's an application.
Well, that might be the your motivation and purpose behind it, but perhaps a simpler way of looking at it is the stay was imposed because you requested that the documents be produced and the bank was not able to produce them, but you no longer press your request for the documents to be produced.
That's it. I mean, I'm a simple-minded man, and I prefer that simple analysis. But that's it.
Yes,
that's it. Could have cut through the last 10 minutes of my submissions, but that's it. That's precisely it. Let's carry on. Let's carry on. Just to wrap up the point, what's happened to the person guarantee is probably more of a matter of interest than anything else. Well, Mr. Bastani has very helpfully given a witness statement at page 2.
Yes, I've read.
You've read that. You've read that. Yeah.
That's right.
Yeah, you read it. Look, it's not going to turn up. I'm willing to stick my neck out and say
unless
that.
there is a request through, I forget what the expression was, the usual formal channels or something.
Yeah, well, what that means is could be anything, but I think what's being referred to there is some sort of MLA request, but the bank hasn't instructed anyone to do that. There's no MLA request that's been made. And as I said in my skeleton argument, there's a fundamental problem with MLA request made by the bank, and that's that I don't know how they're going to grapple with the findings of the Q80 courts, that these are instrumentalities of crime, they are matters of fraud, and what they'll say about it. But be that as it may, the reason why I complete the picture with reference to Mr. Bastani is, and again, I stick my neck out, it's unlikely these guarantees are going to be released by the Q80 courts, them having found that they are instrumentalities of fraud. So that is that. So in my submission, now is the time, and we ask the question for the stay to be lifted and the proceedings to be carried on in this jurisdiction. Can I take to my learned friend's reply to that? So he's produced an incredibly helpful set of written submissions with the quality that one expects from Mr. Lyons, of course. So it's his skeleton argument. And I mean this with enormous deference and professional respect to Mr. Lyons, who is a colleague of mine, but I find his position curious in his written submissions. Essentially what he's saying is, why do you need the stay to be lifted? You've got your judgment in Q8. So that's that. Why do you need a declaration before this court? And in making that assertion, he's put the position, to be fair to him, rather bluntly. Paragraph 18 of his written submissions, he quotes the Court of Cassation's final judgment. Paragraph 19, the decision is final and unappealable in Q8. So that we both agree. Paragraph 22, the claimant has the benefit of judgments in the Q80 court, including a judgment of the Q80 Court of Cassation. Both the claimant and the party are parties to that judgment. The judgment clearly records the finding of the Q80 court on the authenticity of the guarantee. The court, this is paragraph 24, skipping over 23 for a reason. Paragraph 24, the court will have noted that the relief sought by the bank is purely declaratory and not monetary. In any event, the Q80 court has already awarded very modest compensation to the claimant. Additionally, there is no claim brought by the bank against the claimant in this court country. It is emphasized, it should be emphasized that the claimant does not bring a claim to register and enforce, that the claimant does not bring a claim to register and enforce the Q80 court's judgment. Now, there's a reason for that as a matter of law, but such a claim would require fresh proceedings. By inviting the court to lift the stay, the claimant invites the court to make a fresh determination of trial on the question on which the Q80 court has already ruled. Let's stand back for a moment. What Mr. Lyons appears to be saying and recognizing rightly, is that the Q80 court has made its mind up, and it's absolutely plain through 3 layers of determination that these guarantees are forgeries. And what he is saying is that now you've got that, why do you want more? To which I ask this question of Mr. Lyons, and I'm sure he will answer. Does the bank accept that the personal guarantees are forgeries? If the answer to that question is yes, this hearing will be, with the good work between myself and Mr. Lyons, the end of the case. Because if it is accepted by the bank that these documents are forgeries, we can enter into a consent order and dispose of these proceedings. The consent order being the bank consents to the declaration that these are forgeries. If he does not accept that, Kian has a bank which is in possession of an instrumentality of fraud, which is refusing to accept.
Well, that it's not in possession of it, is it?
Sorry, forgive me. I've done that mistake again.
Yeah.
It has out there a personal guarantee which it does not accept is forged. And that is the issue in this case. We have been trying for a considerable amount of time, to say the least, to ask the bank, what is its position? What do you say about the Q80 proceedings? Are you now accepting that you do not have an enforceable personal guarantee? Because we want that reassurance. Why do we want that reassurance? Is because there is a personal guarantee out there, which you say in your defense, and I've taken you to it, Your Honour, has been done, and we are not telling the truth about its enforceability. Now that those Q80 proceedings have been resolved in Kian's favour, we don't understand why you cannot give the confirmation that you no longer will execute or recognise his personal guarantees because they are forged. And if that is the case, all we are asking for is for you to give that confirmation in your declaration, which we can communicate by consent order.
Is there 2 aspects to what you put? One is, I think you put in terms of whether the bank accepts or acknowledges or admits that it's a forgery. The other is, does the bank, I'm not sure if you used the word undertake, but will the bank say that it's not going to attempt to enforce the guarantee?
So
2 separate things, really.
They are 2 separate things, but of course, the consequence, they're consequential.
Well, they could, but sometimes people don't want to admit something because they may not be satisfied that it's correct, but they might accept the inevitability. Well, let's take it specifically. It's conceivable. I'm not saying what the bank's position is, but it's conceivable that they could take the position that they still think it's genuine. They're not going to admit that it's a forgery, but they accept that having been ruled to be a forgery, they're not going to attempt to enforce it anywhere.
Well, I'm going to take you to, I see that. I'm going to take you to a letter which has been written by, well, we asked that question at the end of the Q8 proceedings, and we never got an answer. We never got an answer. It's cited in my skeleton argument. Never got an answer. So what we have is the bank saying we've got a defense, a live defense, which says it's all a lie, as in what we say is untrue, they're genuine. And we now have indication by my learned friend's firm now on record that they will pursue the defense as it is, and they're asking for that cross declaration as well. That is a deeply unsatisfactory state of affairs. All that we have asked for is clarity. All that we've asked for is recognition finally by the bank about what the Q80 court is saying. And the way in which my learned friend has very, I mean, it's complementary, in a complementary fashion, very skillfully dealt with in his skeleton arguments to say, well, just don't lift the stay. That, you know, why do you need to lift the stay? That's fine. What we are asking for is the certainty of the bank saying this is a guarantee that we accept is forged. And I yet to hear from my learned friend what his position is in regards to the guarantee. And that's why I pose the question in the way that I pose it. And from that, everything flows. Because if the answer to the question is, yes, we accept that this is an unenforceable guarantee, unenforceable, and accept what the Q80 court has said, we don't need to entertain the discussion as to whether this is a Part 8 or a Part 7 claim, because that's the end of proceedings. If the bank says no, we still contest, we still say this is a forged, this is a genuine, enforceable personal guarantee, then that is why we seek our declaration to say, well, come on, we have to deal with that. And from there, my learned friend says, well, this is a Part 7 claim. It's not a Part 8 claim. I have submissions about that. Before I recognise I posed the question, and I say that's the material question. But before I hand over to my learned friend, can I deal with the possibility that he says, nope, we're still carrying on, still a genuine PG, still. And I've dealt with that in my skeleton argument. And often when you sit and write these things, you think I probably couldn't do it better orally. So can I take you to, or maybe that's just me, can I take you to my skeleton argument, the material paragraphs, which I know, because you've indicated already, that you have read.
I have read it, yes.
The way I've approached it is, and I assume there were your honour's directions given by email. Two limbs to the directions. The first one was, well, what do you say about the stay? Well, I've just dealt with that. The second one is, well, what's the evidence? What's the evidence? You say Part 7, what's the evidence? And again, don't worry, I think just Lyons and I are still going to be very good friends and probably go for a drink afterwards. But I will say this, the skillful way in which he's dealt with that question needs more scrutiny, because what he's effectively said is, in his reply evidence, this is the kind of stuff that we would be looking at. This is what we would need. And I dare say any highly able practitioner, as like myself, like Mr. Lyons, would identify a shopping list of things that he would need. The question is, and the question the court asked with respect is, what is there? Where is it? Who is it? From 2017, 2017, for several years, you've litigated this case in Q8. Where is any of that material? You were on notice from 2017 about this point. Where is it? These are fraudulent guarantees. The allegation is that the bank is in possession of an instrumentality of crime. Surely, at one point, there must have been at least a momentary consideration to work out what happened. Where is it? And this is what I put forward in paragraph 47. Thus, the critical question is, where is the evidence that the bank desires to adduce? And Mr. Lyons answers it in 3 ways in paragraph 48, and I put it squarely in paragraph 49 and the subs that follow after that. Sub 1, 7 years of litigation in Kuwait. Where's the material? Sub 2, nothing is particularized in the defense. I've taken to the defense earlier. No particularization of the actual meeting and the signing has been done. No particularization at all. It's just a bare denial. Number 3, this, let's not forget what this is. It's 125 million dirham personal guarantee, a debt which the bank has recovered. The idea that a competent commercial lender has not turned its mind to any evidence in support of its claim for enforcement, I say beggars belief. And not only that, Your Honour put squarely the question, may we please know what the evidence is in your direction? So it's been, the bank's had its mind turned to it. Even now, there has never been a single document for the bank in the entire history of these proceedings from 2017. There's never been a witness statement from any bank employee, nothing. The only thing that we have with respect to him is Mr. Lyons saying, this is what we would hope to get. Where is it? My point is simple, and it's this. If he is seriously suggesting there is a Part 7 dispute of such enormous complexity involving contrary factual information, where is it? Because if there's not, there is no dispute. The claim is very simple. This is what the experts say. May I have a declaration? I don't even need to call any witnesses. I could do the submissions in half an hour. That's what it is. That's what the experts say. May we have a declaration? Mr. Lyons promises much, but the bank is not backing him up. The reason why this information hasn't come forward, which is contrary to all common sense, one would think from a commercial bank, because it doesn't exist. He didn't sign it. It doesn't exist. If it did, it would have shown its face years ago, and it doesn't. So that's my position on that. If I need to get there, what Mr. Lyons says is what he says. I understand it. It's what he would like. I understand it, but test what he says by what took place in Kuwait, because nothing ever turned up. So it is not a complexity. No, there's no disagreement between myself and Mr. Lyons about the law. But in terms of what the dispute is, there won't be anything, because there hasn't been anything, and it cannot be identified. So all that we're talking about is a declaration on the basis of what the experts have already opined, and the question as to what happens.
Mr. Osman, what you've told me so far, as I understand it, there is, you just said no dispute of law. From what I understand it, there is but a single dispute of fact. Did the defendant sign the personal guarantees?
Correct. Or I could frame it. Yes, absolutely. Or I could frame it a slightly different way. Is that personal guarantee genuine? It comes to the same point. Comes to the same point.
Now, the only difference, the difference between you, I think, is if I pass over the first hurdle of lifting the stay, the difference between you then is this, is it, that you say, list the matter for hearing. What Mr. Lyons says is, well, we want to go through some interlocutory steps. We want to have disclosure, I don't know what else, disclosure and time to put on witnesses, I think, is what he's saying.
Well, it's the panoply of Part 7, which is the whole track.
Oh, yes, so, but I'm looking at what the consequence of it, the difference between whether it proceeds as Part 7 or Part 8. In practical terms, does it come down to whether, if it stays as Part 8, it goes directly to a hearing? If it becomes Part 7, then there may be these further interlocutories, or these steps of disclosure, and then further time for the defendant to put on witnesses. Is that the practical difference?
That would be an optimistic view of Part 7. The fact of the matter is that if it's Part 7, then no doubt the parties will take advantage of the full procedural.
Oh yes.
Advantages of Part 7, or advantages or features of Part 7. So discovery and disclosure is said lightly, but the process is highly expensive and it's lengthy.
Oh yes.
Witnesses, etc. I mean, if there are witnesses, well, we haven't seen any witnesses. No idea. But I make this point. The reason why we have adopted this process in regards to Part 8 is because it is an elegantly simple question. And we have been dealing with this since 2017. The idea that we now go to Part 7 in 2024 to deal with this dispute, with the court already deciding that the guarantee is a forgery, is, in my submission, not the way to proceed. The bank has had the opportunity.
If you just humour me if you could humour me for a few minutes on the question of disclosure, from your side, is that a large exercise? Have you got much in the way of disclosure? Given that your clients are as an individual, you're not. It's not the company that is the defendant. So, would that be a burdensome exercise from your point of view? Your client to give disclosure of whatever he's got?
The disclosure rules require us to do the searches.
Yes.
And the searches, I think we've all been in litigation when this has happened.
Yes.
You've been asked to search for something that doesn't exist. Well, that doesn't mean you don't do the searches. It just means that what comes out the other end. The
searches have got to be reasonable ones. And as I say, it's different, it seems to me, if it's a corporation than whether it's an individual. Your client, for example, may be corrected, but it's not for your client to conduct a search in, what was the name of the company? Pacific.
P.J.S.C, Pacific Control System.
Yeah, it's not. Your client is not required to produce documents in the possession or control of that company. It's not required to conduct searches for documents in the control of that company. He's required to conduct a search for documents in his possession or control. Now, I don't know, he may have what you tell me. It's why I ask you how burdensome that is likely to be.
It's unnecessarily burdensome because the searches have got to be done. But if this goes to Part 7, I can't apply for summary judgment in Part 8 because there's no rule. The rules do not permit me to do so. So this is what would happen in Part 7, and this is why actually.
Sorry, you can apply for summary judgment in Part 7.
Exactly.
Yes.
So what's going to happen? I can say this openly, quite openly.
Yeah.
If this is taken to Part 7, I'll apply for summary judgment immediately.
Yeah.
Because no material exists. So before we go through the disclosure exercise, before we do anything else, let's go to summary judgment. The question therefore becomes, what's the point?
Okay. If
you go to summary judgment, that's what's going to happen. They haven't produced anything. Nothing's been done. I'll put them to task on all of this, and we'll be in summary judgment territory. So, as I can understand why Your Honour is exploring, of course, the possibility. I would always assume you. I always would, but I'd understand why Your Honour is asking me to do so and explore that possibility. But the result is going to be the same. The result is I apply for summary judgment. The bank won't have anything, and that'll be the end of the process. So, what is the point of moving it to Part 7 when Part 8 needs to go to determination based upon that simple question? That's the answer. So, all that my learned friend says about what's required and so forth and so on is good in theory when you map out a case strategy, as we all do as practitioners at the beginning. But that's not the question. The question is, where is this stuff that you promised? Jam tomorrow. It's not there. So That's the position on part 7. No one's trying to shut anyone out of anything, but the reality is you've been given ample opportunity, and having been given ample opportunity, that more than any ordinarily would be afforded since 2017 and parallel proceedings elsewhere, nothing's there. So why are we moving to part 7? The inevitability being I'll end up applying for summary judgment anyway. If my learned friend said, here is a draft witness statement, here is the whatever it may all be, here's the identified person, this is what we found about Zishan Mahmood, he may indeed have a point. He may say this is where we're progressing in terms of disclosure, but that isn't the case. So that's why moving tracks, although in theory is something to explore, in reality is not going to result in any difference to where we are in part 2. So let's stay in part 2. So that's my submission in relation to that. But I don't want to detract away from the fundamental question. Perhaps the thing to ask, and I will hand over to my learned friend now, with your Honour's permission, of course, is what's the bank say about these guarantees?
Yeah. All right.
Can I assist you any further at this stage?
No, I think that's clear.
Thank you.
Thank you, Mr. Osman. Mr. Lyons.
My lord, on the question of the state...
Mr. Lyons, can I tell you that whilst I'm delighted to be called my lord, it's not a title I'm entitled to. It should be simply Your Honour.
Your Honour, I apologise, and that, as Your Honour will have encountered, is a failing of the English, and I think that there's an old story, as I understand it, which is we laud you too much and honour you too little, I think is the trade phrase. But let me try and correct myself.
And having told you that, Mr. Lyons, I will not raise any objection if you fall back into calling me my lord.
Right, well, Your Honour, let me try to be correct. And Your Honour, Mr. Osman has traversed quite a lot of the material, and I don't want to show Your Honour's material which you don't need to see. Right. But I do want to draw Your Honour's attention to a number of documents. But let me start, please, if I may, with the question which Mr. Osman left me with, which is, what is the bank's position? And I think the short answer to Your Honour, with no disrespect, is that the bank, as the unsuccessful claimant in the Kuwaiti proceedings, is not obliged, as any unsuccessful claimant in any proceedings is not obliged, to say to the defendant, this is in fact my position. The bank fought in Kuwait and the bank lost in Kuwait. And Your Honour can imagine what the bank's views may be about that, but that is the effect of the Kuwaiti court's judgment. We've all acted for clients who have fought battles and have thought that the court's outcome is right, and we've had clients who think that the court's outcome is wrong. I can't tell your lordship, Your Honour, what my client thinks about the Kuwaiti court's judgment, but what I can say is that my client cannot be compelled and should not be compelled to effectively express a view on the Kuwaiti court's outcome. What Your Honour does know, however, is the Kuwaiti court has come to a landing on that question. Now, I quoted in my skeleton the essence of the Court of Cassation's judgment, and I don't know whether just so Your Honour has it handy. It's worth looking at. Can I just show you page 148 of the bundle?
In the bundle?
Yes, 148 of the bundle.
Yes, I have that.
And what you can see, Your Honour, is looking at there is the English translation of the Kuwaiti Cassation Court's judgment. And if I may, I'm going to take Your Honour on to page 152 of the bundle.
Yes.
And the essence, we say, of the cassation judgment is in that second paragraph on page 152, beginning whereas.
I'm so sorry, Hugh, I didn't get that reference. Could you just say it again?
I'm sorry, Mr. Osmond. It's page 152 of the bundle, second paragraph. Whereas the court is convinced of this report and the first instance expert report, both reports have concluded the signatures on the two guarantee contracts differ from the respondent's signature. Therefore, such guarantee shall be void. The bank is not thereby entitled to recourse. That is the clear finding of Kuwait's highest court. Notwithstanding that decision of the Kuwaiti court, notwithstanding that there are no extant proceedings anywhere else between the bank and Mr. Osmond's client, so there is no other fight going on. The bank has not brought proceedings before this court seeking a claim under the guarantee. It hasn't brought a claim in the UAE courts. Notwithstanding the absence of any other proceedings brought by the bank, the claimant says that Your Honour's Court should issue a declaration. And in so requesting,
not quite, Mr. Lyons. What the claimant says in the present application is that the stay should be lifted so that the matter may proceed to a hearing. When it proceeds to a hearing, you might, I'm not inviting it, but you might make a submission to the effect that the court should not make a declaration because there's no current controversy, or it's not practical or useful, or the sort of responses, arguments that are sometimes made as to why a court should not grant a declaration. But that's not where we're at today. Where we're at today is whether the stay should be lifted so that those questions can be asked and answered.
But Your Honour, with respect, it goes further than that, because by lifting the stay and inviting a trial of this matter, either before Your Honour or before one of Your Honour's brethren, what this court, the DIFC court, is going to have to do is form a decision de novo on the question of the authenticity of the guarantee and who is right or who is wrong. The court is going to have to let the parties relitigate before it the question that the Kuwaiti Court of Cassation has already determined. And in so doing, what Your Honour would be permitting, at least the possibility of happening, is the possibility of conflicting judgments. Because by going forward to that ultimate hearing, there must be a risk that the trial judge at that ultimate hearing will say, given all of the evidence before me, I take the view that this guarantee is authentic, that the signatures are genuine, and that therefore this is a legitimate, enforceable guarantee. And if that were to happen, Your Lordship, by lifting the stay today, has effectively permitted an issue which has already been determined by the Kuwaiti court to be relitigated. Now, you may say to me, well, Mr. Lyons, doesn't everyone like that, in the sense that my client may well think that that's a great opportunity. I may think, and my firm may think, that the opportunity to engage in that litigation would be a great opportunity. But I'm duty bound, I think, to point out to Your Honour that by conceding or acceding to the request that Mr. Osmond makes to lift the stay today, Your Honour is effectively allowing that case to be relitigated de novo with fresh evidence determined by a judge of this jurisdiction at a trial. And that is, I think, the point I make about my learned friend having the benefit of this decision in Kuwait, not facing any other risks, what he's asking this court to do is to effectively trample, that's probably putting it too high, to go against the res judicata principle. There is arguably a binding res between Mr. Osman's client and my client on this question. We don't concede, because we're not obliged to concede, that there is such a res at this point. But what we are saying is, by lifting the stay, that would be we would be allowed to fight that battle. And there is, frankly, at this point, no need for that risk of conflicting judgment to be engaged with by this court, because at the moment the bank takes no aggressive steps against Mr. Osman's clients. If the bank was suing in this jurisdiction for a monetary award under the guarantee.
I just want to wind that back a minute.
Of course.
I'm just trying to think of this notion of a res judicata. I don't know if that can apply to declarations, can it? The principle of a res judicata, isn't it, is that the cause of action merges into the judgment. So there's no longer a cause of action, but I don't know that can apply to declarations.
Well, if that is right, then Your Honour may well think that the bank, if the cause of action has merged and Your Honour is worried about the declaratory issue, the bank would then have no action on the guarantee if there is a res judicata. And so we say that the right time to have the argument is if the bank were to seek to enforce the guarantee either before this court or elsewhere. What my learned friend is doing is inviting this court to run the risk of conflicting judgments. Judicial comity strains against that risk. And my learned friend is asking your lordship to, Your Honour, to run against that risk of conflicting judgments for what we say is no apparent purpose. He doesn't face litigation in this court. He doesn't face litigation in the UAE courts. You may well think that in relation to a guarantee dated 2014 and a debt which arose in 2016, that there would be issues about limitation in any event. But what my learned friend is doing is effectively fighting a fight, or seeking to fight a fight, which frankly is unnecessary. And if your lordship concedes to his request, your lordship is going to run the risk of conflicting judgments. And that is my point, I'm afraid, about my learned friend having the benefit of the Kuwaiti judgment. We say your lordship needs to be careful about where this goes, because if this goes forward, then the trial judge is going to be put in the invidious position of potentially being asked to make a finding which is inconsistent with the finding of the Kuwaiti courts. Because what we don't accept is that the trial judge simply copies out what has been determined in Kuwait. What must be determined by the trial judge is this case on the facts before the judge hearing the case, hearing the evidence before him or her, and making his or her own decision. The trial judge will be influenced by what has been determined in Kuwait, but the trial judge is not bound by it.
Well, I think that's the risk that the claimant runs, isn't it?
It's a risk for the claimant, Your Honour, but it's also a risk for the court, because the court, the concern about conflicting judgments is not simply a party concern. It's a concern about justice, and it's a concern about judicial integrity. It's not simply that Mr. Osman is rolling the dice. It's that this court and the jurisdiction is rolling the dice, because effectively this court and this jurisdiction is at risk of saying to the Kuwaitis, we disagree with you. And one of the reasons the res judicata principle exists is because of that concept of judicial comity.
Well, I come back. Is there a res judicata?
Well, I have not, to be blunt with Your Honour, looked at that declaratory relief point. But plainly, on the simple question of whether the guarantee is authentic or not, that fact has been ruled upon by the Q80 Court.
Well, if you're right on that there is some principle, some sort of estoppel of some sort, then that will result, if the stay is lifted, will result in a judgment in favour of the claimant. And the case will be over. There'll be no inconsistent judgments, and the matter will be over. And I have to say to you, perhaps I come from a particular slant, Mr. Lyons. Many years ago, I was on a court which for some years had lists full of cases that were, as I said, had gone to sleep, were there for years, and we took the view that was rather unsatisfactory and that cases ought to be concluded. That's part of the background to my thinking here, that one way or another this case should be concluded.
Yeah. Well, I mean, Your Honour, if Your Honour lifts the stay, then of course it would be open to me to make a res judicata application. Yeah. And I do not accept, for what it's worth, Your Honour, that if I make,
would that be, Mr. Lyons? Can I just explore that a bit further? Do you mean you would make an application that judgment should be entered for the claimant?
No, we would say that the right solution would be a dismissal of the case.
But that's not the way. You couldn't, if you're going to bring forward some, I hesitate to use the word res judicata, but if we put it estoppel in all its different forms, if you were to bring forward an application that's based on some form of estoppel, that can only result in a judgment for the claimant, can't it?
We say that a credible outcome would be a dismissal of the cause of action, because effectively the cause of action doesn't exist in this jurisdiction.
Well, that comes. That's if there was a res judicata, and it had, and the. I'll go back a step. If the claimant is suing on a cause of action, and if the cause of action is merged in a judgment, then somebody may come and say, well, they've no cause of action because it's merged in the judgment. Now that's where, and let me take that a little bit further. If there was an action in one court suing on to enforce the guarantee, and there was a decision on that, then one might say that another party can't commence an action in another court on the same cause of action because it's merged in the judgment. But I don't know how that can apply, and I'm sorry, we're back to where we were a little while ago. I don't know that applies to declarations.
Well, I mean, and to be fair to Your Honour, and I'll be blunt, I'm not in a position to argue that particular issue in front of Your Honour. But the short point is this, which is that when Your Honour comes to exercise, I mean, Your Honour can. I'm
sorry, I want to stop you again, Mr. Lyons. Yeah. When we talk about not in a position today, it also seems to me that the argument that you are foreshadowing, or perhaps not even foreshadowing, saying might be there, are arguments which might be raised on the hearing of the matter in answer to why the claimant should not be given the relief it seeks, or any relief, and may well be open to you to argue all that. But I'm struggling with the idea that the action shouldn't be allowed to go on, because if it does, you might argue that and you might be successful. Well, or it might result in some other action.
No, Your Honour, I wouldn't put it in those terms. The way I would say to Your Honour is that Your Honour should exercise his case management discretion at this juncture, because he is concerned about the risk of inconsistent judgments.
All right.
And because there is no apparent reason for this case to need to go forward. So Your Honour is effectively continuing the stay, not coming to a final decision on the res judicata regime, and that's why I didn't put it that high in the skeleton. It's effectively looking at the risk of offending judicial comity and looking at the lack of necessity for these proceedings. That's my first point on the stay.
Well, let me just try and think of that out in more general terms. Supposing that if the stay is lifted, the matter proceeds, and the bank finds 2 witnesses who saw the claimant sign the document and produces that evidence, this court should properly find that the signatures are genuine and the guarantee is genuine, shouldn't it? It wouldn't say, oh, we shouldn't do that because that might be offending some sort of judicial comity.
In those circumstances, if I came along today and I was the one arguing for the lifting of the stay, and I had that evidence in my back pocket, and I could invite your lordship to look at that evidence, of course, what we'd be saying is there is a risk of the offence of judicial comity, but the proceedings are needed because the bank wishes to push forward with the guarantee and has credible evidence that the guarantee is in fact enforceable. The reason for the litigation proceed is plain in your Honour's example. What Mr. Osmond does not have to counter the concern about judicial comity is any good reason why this case needs to go forward. So that I say is the distinction between your Honour's hypothetical.
Well, that would be, and that may be, an argument on the final hearing. As I said, I came back to, as we know, declarations are discretionary remedies, and amongst other things, the court looks at, say, whether there is a current controversy, and that raises the point which you have rightly said. Your client doesn't have to say what it has to say about the Kuwaiti judgment, but it may be a question, no, not maybe, I think when the court came to consider whether it ought to make a declaration, amongst the things the court would consider is whether there is a current controversy about whether it's a genuine signature, whether the personal guarantee is genuine or a forgery, and the court would have to look at all of the evidence to determine whether there's a current controversy on that. Similarly, if there's the court's got to consider whether it's practical or useful to make the declaration, the court will be asking the claimant why. But those are all matters that would go to the question of final relief. It seems to me premature for me to be embarking upon those questions on an application to lift a stay which was granted for procedural reasons.
Your Honour has my submissions on that first limit.
Can we move then to the second question?
Your Honour, can I also then address my second argument as to why the stay should not be lifted?
Oh yes, all right.
And that's sorry. So I've got the comity point.
Okay.
But the second reason the stay should not be lifted at this point is because the function of the stay, which is the ability to return to this court and the experts who will have to examine the signatures before this court, is still not able to occur because the guarantee remains.
Well, I don't think that's quite right, Mr. Lyons. I come back to my understanding of the reason that the stay was granted was because the claimant was seeking an order for inspection, that you produce the guarantee for him, the claimant, to inspect it, or for his experts to inspect it. And the stay was granted because it wasn't within your power to produce the guarantee and therefore to give the inspection. Now, where we're at today is the claimant says, well, I don't press for it anymore. So that's all over. Now, it really would be for you to make a new application for a stay if what you're saying is, well, we want the documents. It ought to be stayed because we want the documents so that we can inspect them. That wasn't the basis on which the stay was granted. It seems to me if that was to be a basis for a stay, I should really discharge the current stay and then enable you to bring forward a stay with evidence about why it should be granted to permit you to take that course, because it's a different course.
Well, I'm not going to disagree with Your Honour's understanding of the position, in the sense that what the claimant sought to do was have the guarantee inspected by their their party appointed expert. But yes, it follows from that, Your Honour, that if the claimant was going to lead expert evidence, having had a chance to inspect the original, the defendant would also be entitled to lead expert evidence. And so, in one sense, although the stay was the inspection was sought by the claimant at an early stage, the function of it was to allow inspection by the experts. I use that word plurally because I think that means the claimant's expert and necessarily by the defendant's expert, because effectively if the claimant was going to lead expert evidence, the defendant would also be entitled to lead expert evidence.
All right.
Now, at this point, that can't be done because the guarantee remains with the Q80 court. Now,
Mr. Lyons, before you move off from that point, you've adduced evidence from, I've forgotten the gentleman's name, Mr. P.J.S.C, is it, or?
Bastani.
Bastani. And Mr. Bastani, I think, gave evidence that he was told by somebody that the judge or some judicial officer had said words to the effect that if the bank wants the personal guarantee, it would have to make some application through, I forget what the expression was, the formal or usual channels. Have you explored that and found out what's required and then pursued that? Because you see, if the court were being asked to stay or continue a stay because you've not been able to get the document, it would want to know that you have done everything possible to get hold of it. And at the moment, there's evidence of a possible course and nothing to say that you've done it or that it can't be done.
I was going to show your lordship Mr. Bastani's evidence, so we can yes, both have in front of us what Mr. Bastani says. Right.
Yes.
His evidence starts at page 259 of the bundle 259.
Yes.
And picking the evidence up at paragraph 11, just so your Honour has the sequence.
Yes.
The Kuwaiti advocate, Mr. Al-Turki, makes a formal request to the judge, and that request is made in writing. That's paragraph 12. Sorry, paragraph 11. At paragraph 12, the judge responds in writing, declining the request for the guarantee. Somebody else then speaks to the judge's secretary. It's a rather odd to perhaps our eyes and ears, but this is not uncommon, as I understand it.
Yeah.
To be told the informal reason for the declining of the request. And yes, paragraph 14, again, perhaps rather surprisingly to our eyes, Mr. Al-Turki, the Kuwaiti advocate, goes along to see the judge at an in-chambers conference, or it's an informal meeting, and is told that the judge might be able to assist the courts in the UAE if a formal request was made to the Kuwaiti court through the formal usual channels. Now, what I understood that to mean is that effectively Your Honour would effectively be making a request to the judge in Kuwait saying, I am seized of this case in the DIFC court. Would Your Honour in Kuwait be as good as to give me this document so that I and the judge in the DIFC can determine it? So it is effectively, as Mr. Osman put it, a mutual legal assistance, but it's judge-to-judge communication. Now, Your Honour will have undoubtedly encountered that in his career. Now, we have not made a formal application for that, but I want to canvass that with Your Honour, because what the clear indication we say on that evidence is if Your Honour indicates to the Kuwaiti court that Your Honour needs this document, then the Kuwaiti court may well accede to it. And of course, the concern about this being a false document is in many ways met if it's a judge-to-judge or court-to-court request, because of course, if the original guarantee is mailed to the registry at the DIFC, there's no risk, we would say, of that document being misused. It leaves the custody of the Kuwaiti court and arrives in the custody of Your Honour's court. And at that point, Your Honour can say, well, okay, the expert should inspect this document. You can do because of course, Your Honour has heard forensic handwriting experts before, but effectively they will tell you that the flow of the ink, the impressions on the page, all of that stuff is very, very important to their determination. And the defendant will say that if this court is going to hear this issue de novo, it should be entitled to the opportunity to lead its own expert evidence on this issue. Now, Mr. Osman sought to give evidence from the bar as to the quality of the experts who've already opined. I mean, Your Honour won't, I'm sure, have been influenced by Mr. Osman's attempts at evidence, but what Your Honour, I have no doubt, will recognise is that there will be very, very sophisticated evidence available outside of Kuwait and Dubai, whether that is from former members of, for instance, the Metropolitan Police's forensic lab or the FBI's lab. There are some very, very sophisticated operating techniques which are available elsewhere in the world, and the bank may well wish to call upon such individuals. And we say the bank should be so entitled. And this case has been in abeyance since 2018. It's been in abeyance for 6 years. We say that if Your Honour is instinctively thinking this case should go forward, we say then the right thing to do is to keep the stay in place for the moment, to write court to court to the Kuwait.
Well, I have an old-fashioned view of that, Sir Lyons. The first is that so long as the action is stayed, it's stayed, and there is nothing that I can or should do. The second aspect of it is that I would only consider doing something like that on the basis of a formal application by your client.
Well, then, if that is your Honour's position, and it's a very helpful indication from Your Honour, then what I'd invite Your Honour to do, if that is where Your Honour is minded, is to adjourn this hearing for 7 days to allow that application to be made before Your Honour, so Your Honour has it. Or alternatively,
But the application can't be made and heard whilst the stay is in place. The view I take, which I think is right, I can't see any other approach. So long as the action is stayed, no applications can be made or determined in it.
Well, apart from the application to lift the stay.
Well, of course.
But insofar as if this were to become a condition of the lifting of the stay. So your Honour could say, for instance, that the stay will be lifted if either the Kuwaiti court responds to your Honour's request for the guarantee by providing the guarantee, or if the Kuwaiti court says no to your Honour, or if the Kuwaiti court takes, picking a number at random, 6 months to respond. Your Honour could impose in the determination of this application a conditionality which involves that judicial request, but which effectively is using this application as the lever for that judicial request.
All right.
And we say that would produce fairness. It also is going to address an issue which Your Honour, or whoever hears this case at trial, is going to need to grapple with, which is that Mr. Osmond says, well, we don't need this evidence now. We don't need to see the original guarantee because we have got the report of the Kuwaiti experts. Now, the first point to make is that is a slightly the timing of that is slightly disingenuous. Your Lordship, and I won't take your Lordship to it, your Lordship was shown a letter at page 91, which was Mr. Osmond's instructing solicitor pressing for this inspection. And that letter was dated December 2017. Your Honour was also shown page 190. Would Your Honour like me to take you to that document, just so Your Honour has it?
Yeah, 91 I've seen before.
You have, but what I'm inviting you to look at is the date of that letter, or the date of that email, which is
December 4th
of December 2017. Yeah. And Your Honour was also shown by Mr. Osmond, page 194 of the bundle.
Yes.
Which is the beginnings of the Kuwaiti inspection report. And you'll note, Your Honour, that document bears the date of the 9th of July 2017. So that document, the report, is in existence before the request is pressed in December of 2017. Further, the parties must have been aware of that report because Mr. Osmond told you in his submissions that at the time of the defence in November of 2017, the Kuwaiti Court of First Instance had rendered its decision. So that report, which we were looking at in July of 2017, was in the parties' hands, available to the parties, when Mr. Osmond's solicitor was pressing for the inspection order. And so we say that this is a slightly coy, volte-face by my friend, because it effectively allows him to press on with the case. But there's a timing issue, but be that as it may, the point, the substantive point I want to make is this, is that what does the trial judge do with the Kuwaiti reports?
Well, I don't know yet. If I'm the judge, I'll wait to see what evidence is put up and what form the evidence takes, whether it's admissible, and if so, what weight it has. All of those are problems in the first instance for the claimant.
Well, they are, but what the claimant says is, oh, I don't need expert evidence, I don't need an expert inspection because I've got the Kuwaiti expert reports. But as your Honour's just identified, those documents are not expert evidence in front of the trial judge. They are simply documentary evidence.
Well, that's the claimant's problem.
Yes, it is the claimant's problem, but the defendant must be entitled to meet that evidence. And it says it, and in the ordinary course, the defendant will want to meet that evidence by effectively having available to it the original report. And what has not occurred, as Mr. Osmond eloquently told you, is that the defendant has not had an opportunity in the Kuwaiti proceedings or in the proceedings before your Honour's Court to select its own expert, an expert of true international standing, and to review the original document and to opine on the authenticity of that document. And so we say that if your honour's instinct is to not have this docket stayed on the court's file, we say that the right approach to this stay application is to make the lifting of the stay conditional on a letter being sent by this court to the Kuwaiti court asking for the original guarantee, and either the stay being lifted when the guarantee arrives, or a refusal is received, or after a passage of time which Your Honour thinks is reasonable. And that, we would say, would address Your Honour's concern. It would basically tell Your Honour that actually this case is moving forward, but it would allow the document which caused the stay to arise to either come back into the party's possession through the court, or for the parties just to candidly recognise it's never going to come back into the party's possession, and therefore it's got to be treated as a lost document. Much in the same way as Your Honour will have encountered cases like this where the bank says, we had an original guarantee, it's got lost somewhere in the filing system, all we have is a photocopy. And cases like that progress, but we say that where we know the original exists and where there is a highly fought matter about the genuineness of this document, and the parties stayed these proceedings for 6 years to allow that inspection to occur, it is not asking a great deal for a further 6 months or so to see whether that original document can be brought back into this court's possession. And so if Your Lordship is against me on the comity issue on the stay, we say that the second reason the stay should not be lifted is because the stay should not be lifted immediately, because inquiries should be made court to court for that original guarantee. And I've tried to help Your Honour as to how that order might be carried.
Yes.
In weighing that, Your Honour, we again would emphasise the balance of prejudice. There are no ongoing proceedings seeking monetary judgment. There has already been a 6-year delay. There is no rush to judgment in this case. And for justice to be served a further 6 months delay in the scheme of a case which has been delayed by 6 years is, we say, not a great deal to ask. And therefore we say the balance of convenience is very much in favour of that inquiry being made court to court for the guarantee.
Yes.
Your Honour, moving to the second question, on the question of whether these proceedings should stay in Part 7 or Part 8. Mr. Osman has candidly admitted that this is a case of forgery. It's a case where effectively it is being alleged that the signature is forged. It is also, as advanced, a case of fraud, because, as I set out in the skeleton, it is said that the certificate provided by the bank's employee on the face of the guarantee is a, quote, false certificate or a false certification. And Your Honour may have seen in his pre-reading that basically there are detailed particulars, well, relatively detailed particulars of claim pleaded as to the falsity of those documents. But can I take Your Honour, perhaps, to the witness statement of the claimant, which was served in support of this Part 8 proceedings, and that is at page 28 of the bundle.
I have it.
It was ahead of me. just because we're in it and Your Honour has this, at paragraph 2, you see the shareholdings in the Pacific Control Systems company. You see that the claimant and his father own 35% of the company. And Your Honour will have seen, of course, that the guarantee given in favour of my client is for a substantial 125 million dirham. And you'll also have seen that this company has incurred indebtedness in total of in the region of 1.4 billion dirham. And that was evidence in my third witness statement, citing press reports in 2016. So Your Honour is dealing here with a very substantial entity. Now, in light of the fact that the claimant and his father have a very substantial shareholding, and that this company is a very, very large enterprise, paragraph 8 of the claimant's witness statement may strike Your Honour as somewhat surprising. The assertion that the 35% shareholder of a company which could borrow 1.4 million dirham has delegated all management and basically information flow to the executive management. And the evidence being given is that this is something which, this is a company which we just...
Right, Mr. Lyons, I'm no longer amazed by any of these things I see.
Well, perhaps amazed may be the wrong language, but Your Honour may strike Your Honour as odd, given Your Honour's experience elsewhere. But
these things do tend to vary from one place to another, I find.
Yes, but perhaps the central point is that it's part of the claimant's case that they knew nothing about what was going on in this very, very, very substantial company in which they had a 35% shareholding. We say that is a factual allegation which will need testing at trial. But moving through to what else the...
So when you say it'll be tested in the trial, you mean he'll be cross-examined?
Well, he would be cross-examined, but also the bank could rightly say the question, the knowledge of what you knew about P.C.S.'s business is a matter between the claimant and P.C.S. The bank may have some evidence to give about it, but actually that's principally an issue as between the claimant and P.C.S. And the bank's going to say, in order to test the truthfulness of this evidence and to test whether or not the claimant really did know nothing, it's going to, he is going to be subject to cross-examination, but he's going to be subject to cross-examination in relation to documents which need to be disclosed on this and other issues. So the reason I lead with this is that this is flagging what I'd say is a slightly unusual assertion, but it's also a reason why when we get to look at why Part 7 proceedings are needed, this is exactly the kind of stuff where effectively material in the claimant's possession, communications between the claimant and P.C.S., provision of documents by P.C.S. to the claimant, all of that stuff will be tested in disclosure. If the claimant is right, and as Your Honour was putting to Mr. Osman, if he has nothing, he will conduct a limited search and he'll say, I have nothing. But he's going to have to effectively conduct that search, and more importantly, his lawyer's going to have to conduct that search on his behalf. And he's going to have to effectively confirm to this court that what he says, that he has no documents, is true. And we say that this, again, is just part of the evidential framework, which in the ordinary course of a case like this would effectively lead to cross-examination, but would also lead to disclosure at the first stage of the case. But turning on, there are detailed factual assertions in the Yazdi witness statement. Paragraph 12 Prior to February 2017, the bank had never shared copies of the PG with me and my father. So that, again, is going to be a documentary issue, which both the bank and Mr. Yazdi can speak to. But also,
well, when you say documents to which claimant and the bank can speak to, presumably the bank's had 7 years to look for these documents. It will have found them and be all ready to go with that.
Well, that is a point which Mr. Osmond makes, but with the greatest respect, Your Honour, the answer is it all depends on what is required by the jurisdiction in which you're fighting. Your Honour will know that there is no disclosure in this broad region apart from the DIFC court. So the idea that the bank or the bank's lawyers will have said to him, you must go and undertake disclosure, is not, we say, a safe assumption. It's not. No.
What I'm saying is not that the bank would have obtained disclosure from somebody else, but the bank will have gone through its own documents.
Well, I caution Your Honour against so assuming, because it would only do so if it felt that it was able to lead that evidence before the court in which it was litigating. And I think Your Honour, when he reads the judgments of the Q80 court, will see that a great deal of emphasis is placed upon the expert reports. And Mr. Osmond, again, giving evidence from the bar, tells Your Honour how the experts are central. We say that Your Honour should not assume that just because the bank hasn't looked and found them yet, it hasn't got them. We say that Your Honour has to conclude that actually the bank hasn't yet had the starting gun fired in a set of proceedings in which that kind of material is sought and advanced. And Your Honour, we say that this is exactly the kind of stuff which the bank should be given a proper opportunity to look for its records, but also the claimant should be asked to turn over his records. Imagine the bank passed a copy of the guarantee to the company, P.C.S, and invited the company to hand the guarantee to the claimant. Now, Your Honour knows that the company must have had the guarantee just from its very existence. So the question of whether the guarantee was passed by the company to the claimant is, again, a factual matter which is not in the bank's knowledge, and the documentary evidence of which will not be in the bank's control. Turning through, can I just show Your Honour some more? Your Honour can see at paragraph 14 the clear assertion of forgery. Paragraph 16, some more clear assertions of forgery. The PG is not my signature, is not my signature. Paragraph 17, more assertion of forgery. But the kind of factual issues which might need to be tested at trial are summarised at paragraph 20 of this witness statement. This is the claimant's own evidence, which we, of course, would wish to test at trial. He wasn't at the bank on the date in question. He hasn't executed the PG or authorised anyone to execute it.
How are you going to test that?
We would say that documentary evidence, the disclosure obligations would be central to that. You know, whether somebody attends a meeting are questions like invitation emails, text messages from the claimant perhaps to his father. Dad, are you coming to the meeting with the bank? Diaries which the claimant may maintain.
So it goes back to disclosure.
It's a disclosure point, and of course, once you have that disclosure, then effectively you're going to cross the witness at trial on these detailed matters. So the reason I do it this way around, Your Honour, is that it shows, Your Honour, why the Part 7 tools, the disclosure tools, the witness statement tools are going to be essential. But actually it shows, Your Honour, why there is a substantial dispute of fact between the bank on the one hand and the claimant on the other. This is not, oh yes, we all agree that there was no meeting. This is stuff which there is going to be a hard-fought match, swearing match about before the trial judge as to whether this is true or not true. And the bank.
Well, at the moment, that might be right, but at the moment it's not a swearing match because it's not oath against oath, it's oath against nothing.
And Your Honour, the reason for that is the bank has yet to put in evidence, because Your Honour sees, and Your Honour sees from the procedural history that what the bank has done is, on receipt of the Part 8 proceedings, it said from the very get-go, it said in the acknowledgement of service, as it's meant to, Part 8 is not the right way to proceed. It then filed a defence.
I find it odd, Mr. Lyons, whilst we're on that, I would find it odd if the bank had not asked the two witnesses who were said to be verified the signatures. I would find it odd if the bank had not made inquiries whether they're still alive, where they are, and what do they have to say about it. It would seem to be pretty simple.
Your Honour may be so surprised, but Your Honour's surprised, with the greatest respect, should not, we say, stop the bank being entitled to pursue the remedies in front of it.
Well, sorry, I'll reframe it. Of course, my surprise is not relevant, but the point that I made inelegantly is that the bank has had an opportunity to make those inquiries.
The bank has had an opportunity to make those inquiries, and Your Honour doesn't know whether the bank has or has not made those inquiries, because and the claimant doesn't know whether the bank has or has not made those inquiries.
Well, all of that goes to this, doesn't it? That what you say, as I understand it, is, and this is all predicated on the stay being lifted and the matter going forward, you say it should go Part 7 rather than Part 8 because you want disclosure and you want to put on witness statements.
And I want to put on expert reports, and I want substantial cross-examination. Now, I mean, I don't know whether this will assist Your Honour, but Your Honour will also have seen, I'm changing direction slightly, that two other banks have obtained judgment against the claimant in relation to guarantees. And that judgment was obtained in the Dubai.
I'm sorry. If Mr. Lyons wants to go down this road, we're going to be here for another hour. It's not a useful submission, because there is other additional witness evidence that we have put in, which gives the true picture of what's happened. It's not relevant to this hearing, but if you want to do that, we'll do it.
I'll take Your Honour to that additional witness evidence.
But before you do, where are you going with it? What's the point?
Well, basically, there is now a fight before the English court on the question of whether the UAE judgment is enforceable. And central to that question, as advanced by my learned friend's client, is the question of whether there is the documents are a forgery. And all I was going to show Your Honour.
And why is that relevant to me?
I was going to show Your Honour the trial directions made by the English trial judge, or the English judge, in relation to a trial of that issue. And the reason for that is that Mr. Justice Knowles, in the English courts, when being asked to look at this question of whether or not there has been a forgery, whether there has been lies told to the UAE courts, what Mr. Justice Knowles does is he lays down directions for.
Where are the directions?
I feared Your Honour was going to ask me that question, and let me just quickly find that so Your Honour has that to hand. I should make a note which is incomprehensible. So, can I take Your Lordship to paragraph 280, sorry, to page 284? And this is a different case. I totally accept it's a different case. But in essence, it's a case between a UAE bank and the claimant. And there are other defendants as well. But importantly, from 284 onwards, you see how the English commercial court deals with this issue. It deals with the issue by ordering disclosure, by ordering witness statements, by ordering expert reports, and a 16-day trial. Now, we're not saying that your lordship needs to copy, your honour needs to copy out those directions, but we say that when the boot is on the other foot and my friend wants to basically say that there has in fact been a forgery, that is the kind of way that the court deals with the issue. This apparent shortcut, which is now argued for, we say does not occur in those proceedings. And your honour may think it's a jury point, but we say that actually your honour sees how another court deals with this issue and recognises that there needs to be comprehensive material before.
Well, Mr. Lyons, I'm always interested to see how other people deal with things, but every case is different. And whilst it might be interesting to see the directions that were made in that court, of course, it would be necessary to see what, if any, directions are appropriate in this case. And I must say, I sometimes look at other judges' directions as a guide of what sort of directions you might make, but in the end, it comes back to what's appropriate in this case. And I think, with respect, we haven't really gone any further than if it should go to Part 7 so that you can have the use of disclosure and filing witness statements. And I think if you get to it, expert reports or expert evidence.
Yes, I mean, I can. We would say that expert evidence is going to be needed one way or the other if the court so directs, because the court is going to be faced with a handwriting issue. If there isn't the original document, there's going to still be expert evidence. It may not be of such high quality because the experts are going to say to your honour, or whoever tries it, reviewing copies is not as informative as reviewing the original. But from what I've seen, I say X and the other expert says Y. But, you know, if my friend wants to, as he indicates he does, wants to have expert evidence, both from his expert, Mr. Al-Bar, from whom he's already led evidence, and also introducing somehow the evidence of the Q80 expert reports, notwithstanding that those experts are unlikely to come before this court for trial, then justice says the defendant must be entitled to have expert evidence. And then the trial judge has got a potential conflict of evidence before him.
Can I come back, Mr. Lyons? It's all very interesting, but it seems to me where we're at is this. You say that it should go to Part 7 so that you would have the opportunity to get directions for disclosure, witness statements and expert evidence. I don't need to go into if that were to come about, what the directions should be, who the witnesses should be, and so on. That's for another day, if we got there.
I don't disagree entirely. I'm not going to invite your honour to make detailed directions today. But what unless your honour is so minded, but what I wanted to illustrate to your honour is the broad range of factual matters and expert matters which are going to be before the trial judge at a case like this. Did the meeting occur? Had they seen the documents? Were they involved in the management of the company? What did they know about the banking facilities? Those kind of issues are going to be before the trial judge. They are going to be substantial.
They might be. Depends whether there's any evidence about any of it.
Well, I see that, Your Honour, but what there must be is an opportunity to lead that evidence.
Well, I keep saying, I understand your point is that what you're saying is it should be Part 7 so that you've got the opportunity at least to seek disclosure, witness statements and expert reports.
Yes. And Your Honour has seen, and I'm not going to belabour it, that the threshold test laid down the cases is there a substantial dispute of fact? And Mr. Osmond suggests that substantial means of substance. I say that is not what substantial means in this case. What substantial means is extensive rather than of substance. And if Your Honour is interested in that, perhaps the last thing I'm going to show Your Honour is the notes to the English White Book, which may be a brave move, but that was one of the authorities I sent through last night and put on the.
Oh yes. Now, let me see if I can find that. Yes, I have that.
So if we could just open, it's a 10-page PDF. The good news is I don't need to move Your Honour past the first page.
Oh, okay.
Can I show Your Honour on the first page? There's about 4 paragraphs down. There's a paragraph beginning. There are 2 distinct types of claim. Does Your Honour have that?
Wait a minute, I'm just noting the page down now. There are 2 distinct types of claim. Yes.
Yeah. There are 2 distinct types of claim in which the Part 8 procedure may be followed. The first category is where the claim seeks the court's decision on a question which is unlikely to involve a substantial dispute of fact. These claims will normally be heard and disposed of on written evidence. And then the examples are claims for declarations as to the construction of documents, questions of law, and administrations of the state are usually appropriate for this procedure. Now, we are a million miles, I say, from those kind of examples. But then reading down, you can miss the second category out, because what the second category is claims where the Part 8 proceedings is expressly required by statute or practice direction. And they're going to direct Your Honour to the paragraph beginning unless falling within the second category, contentious claims involving substantial factual disputes will not usually be suitable for the Part 8 procedure. How the court may, in appropriate circumstances, approve a hybrid procedure under which limited, and I'd underscore the word limited, factual disputes requiring oral evidence can be accommodated. And there are some examples. Now, and then if you read down to the next paragraph, in essence, the Part 8 procedure is designed for the determination of relevant claims without elaborate proceedings. If the procedure is misused, the defendant can object, and equally the court on its own initiative can interfere. The Court of Appeal in ING, and I've put the ING case in the authority, expressly approved this passage and stated in general the Part 8 procedure is wholly unsuitable for the trial of an issue of estoppel. And we say, of course, that this is far more complex or far more fact sensitive than an issue of estoppel. But the key point I wanted Your Honour to draw out from that is that the guidance in the White Book is that you can use the hybrid procedure where there is a limited dispute of fact. Now, we say that the word limited assists Your Honour in understanding what substantial means. We say that limited is used by the authors of the White Book as in contradistinction to substantial, and therefore we say that what Your Honour takes is that substantial means extensive, and what it doesn't mean is the proposition put forward without any authority by Mr. Olson, that substantial means with substance, and he says you haven't identified what your evidence is. That was my short point. But Your Honour sees that the guidance from the White Book is that this is for things such as construction of contracts, questions of law, and issues on administrative estate. We are a million miles from those kind of cases, and we say this is an example of the claimant, perhaps wishfully and without malice, misusing that procedure. and therefore, Your Honour, we say that Part 7 is the right procedure. Your Honour has, I think, all I want to say on that.
All right. Thank you very much. In reply, Mr. Osman.
Does Your Honour wish submissions in regards to the lifting of the stay?
No.
In relation to Part 7, Part 8, can I just identify a couple of issues? The first, in fact, it's an invitation more than anything else, and that's just to stand back. Again, all that Mr. Lyons says about what should be available is very different to what is available. And when we're looking at substantial disputes of fact, there must be something there to dispute. And at the moment, there isn't, apart from Mr. Lyons' intentions about what he would like. I've called it the Lyons shopping list. There isn't anything there. And in regards to the history, Your Honour may find it surprising that during the entire course of the QA2 proceedings and being on notice of what the defence is, that the bank has not even started to look for anything. And Mr. Lyons was very careful. He didn't say explicitly the bank hasn't, but that you cannot assume that the bank has. Grasp the nettle. If it's there and it's of substance and not of dispute, then you would see it, because this is Mr. Lyons' opportunity to argue a move to Part 7. Can I deal with disclosure? Because I'm not sure if Your Honour has had the opportunity to be part of the disclosure exercise in regards to trials before the DIFT. Hugh, I'm so sorry. Do you mind just going on mute for a moment? It's just I can hear the rustling. Thank you. Thanks. Thanks. I don't know if Your Honour's had the opportunity to be part of a trial in this jurisdiction and how disclosure operates. If you have, then I can shortcut this quite considerably. If you have not,
limited, so perhaps you might make the point you were going to make.
Production of documents is under Part 28 of the rules.
Yes.
And it's very similar to the arbitration approach to disclosure. Yeah. So it's completely different to how the English courts deal with the issues of disclosure, which I can say from experience is infinitely more complex. But the process works like this: is that production copies is done of documents, is done by the party who's leading the particular evidence. It's precisely like arbitration. That's 28.3. And then documents referred to in statements of case, if there are referred to, then there's a disclosure request made in relation to that. Effectively, it's an extension of inspection. And then there's an attempt to cooperate between the parties for that material, and the standard production of documents, any documents which the party intends to rely upon, 28.15, all documents available to it, 28.15.1, all documents available to it on which it relies, including public documents, etc. Then there is the request to produce in 28.16, and that's the request to produce description of a requested document sufficient to identify it, etc., etc. So it starts with production of documents upon which the party is to rely. And so it does feed back to the point I made earlier. The idea that the bank hasn't turned its mind, if it is inviting this court to move to Part 7, to assemble the documents upon which it relies, is quite remarkable. So what does that mean? What are we going to get? It is why the key question that I've invited my learned friend to focus upon in my written submissions, I've made the points, and in oral submissions is, what have you got? Because if you haven't got it, there is no disclosure. If there is no disclosure, why are we in Part 7? That's what it comes down to. Taking the other side, what have we got? We've demonstrated, we've said in evidence, we have no knowledge of this. We don't know anything about it. There's nothing for us to produce in support of our case for the production of documents. So that's not going to happen. The only possibility, if at that point, no party is producing any documentation upon which he wants to rely upon. My learned friend hasn't identified what they are. We say that we don't have anything. That in effect is the disclosure exercise. So this is why it's important to grapple with the issue what the bank has now to determine whether actually the disclosure process will be something that means anything in Part 7. And that's and my learned friend, with respect to him, has not grappled with that point. If we're going to go down to Part 7, what are you going to give? If you're going to give something, what is it? If you haven't got anything, why are we in Part 7? Because there's no disclosure. There's that point. The other point is this, that your Honour will be completely familiar with the law in relation to summary judgment. I know that because it's the day-to-day business of the High Court to deal with that. I don't have to go through all the telecom, etc., EasyJet, Easy Area, and so forth. But the authorities are crystal clear. You will not be able to defeat an application for summary judgment on the basis that there might be something that turns up later on. That's
well, you've got to be able to point to what it is and the likelihood of it, the nature of it, and so on.
Exactly. So I say this, and I've said it previously, if we move to Part 7, the first thing that's going to happen is an application for summary judgment, which I'm not entitled to do in Part 8. So I'll do in Part 7. So what is the point in moving to Part 7 if there hasn't been an identification of information that is deployable and what is at hand by the bank and what will be disclosed? And because my learned friend hasn't met that threshold in my submission, there is no point moving towards Part 7 because Part 8 is going to look like Part 8 as we move into Part 7. So there is no function in what he seeks to do by moving to Part 7. What appears to be happening with reference to the fact that maybe we should wait 6 months, maybe we should ask the court to ask the other court to help. Well, we haven't made an application for an MLA relief. There's a real question as to what procedure would be applied. We don't need to go into that. That's a hearing that will probably take a day in itself. But it's not as straightforward as my learned friend seeks for it to be. But the idea that we should wait 6 months to lift the stay for that to happen, the idea that we should go down Part 7, the idea that we need to investigate this and we need to investigate that because something has happened, all points to this. The bank does not want to grapple with the fact these guarantees are forged. It doesn't want a determination in this court. It doesn't want a determination soon. It's trying to drag this into the long grass. It's 2017 since it started, and Your Honour made precisely the point. And it's something which is shared in our jurisdiction. And for these purposes, I'm talking about England, where I sit. Courts are highly reluctant to let matters lie in abeyance. That is not the way that litigation should proceed. Cases just don't float in the ether. Nothing happens to them. There needs to be some sort of disposal. Every modern court in common law jurisdictions and perhaps even civil jurisdictions will adopt that process. You cannot start a case, have it sit on a file and just let it sit there forever, which is effectively what my learned friend say. Something needs to happen. I've invited my learned friend to dispose of these proceedings today by accepting by consent that this is a forged unenforceable guarantee. If they are not prepared to do that, and I just didn't get a straight answer out of them as to what the bank's attitude is, I'm afraid to say. Not clear. And the lack of clarity requires us to obtain satisfaction by way of the finality of judgment. My point in relation to Part 7 is that this is another instance of the bank just trying to push off that decision because it's an uncomfortable decision for them to make. And I invite Your Honour not to be attracted to the idea of doing that because this is an elegantly simple case. Guarantee has been looked at by experts. My learned friend possibly crossed the Rubicon by suggesting the QA2 experts weren't competent, possibly, but they were. And that's what the position is. So all I would do in a trial of issue, insofar as there is one, is I would say, I'm not calling any witnesses. I'm just using that, what's happened in Kuwait by way of the factual evidence of the experts looking at this. And that's it. It's a matter that will probably take half a day, no more. And that's it. I wouldn't need to call anyone else. That now is what I would rely upon. And I just want to take you to one document, to one aspect of the bundle, which probably shines a light on the bank's position. It's 185, page 185 bundle. Be so kind just to indicate when you have it.
Yes.
So this is the translation, and this is actually quite a good one, of the preliminary judgment of the commercial court. Just tracking back slightly, I did take you to the reports. I won't point it out now, but the reference in one of the reports by the experts was a reference to the request that the court had made on a particular date for the work to be done. That is this. The preliminary judgment was, obviously, because it's preliminary, a precursor to the final judgment. Turning over the page to 185.
Yes,
both parties. The lawsuit was deliberated as indicated in the minutes of the sessions thereof. Both parties, the lawsuit represented by attorney. Good. The representatives of the plaintiff bank submitted a document which included the following documents. Furthermore, at a hearing of the session on the 30th of April 2017, the representative of the plaintiff bank submitted a defence motion which was pursued by the court. The representative of the plaintiff bank requested at the end of the moratorium a memorandum, a judgment to appoint an expert to perform a task mentioned in the statement of claim. It's all well and good for Mr. Lyons now to say, well, these Q80 experts, they're from Q8. Maybe they're not as reliable as what we'd like. We really need the opportunity to test it. The bank asked for this. This was the preliminary judgment. This was the preliminary ask from the bank. Dear court, we want you to look at, we want you to appoint the experts. So this is what it is difficult to now accept that the bank is saying, well, that process wasn't good enough. We need to have it done again, etc. And this is another reason why it goes to Part 8. They asked for it. They don't like the result. They appealed it, and it was upheld. The point is this. This is the evidence that the bank asked for, requested, and it got, and this is the result. And that is what I would put forward in a Part 8. It's difficult to undermine the quality of what I would be deploying when it is the bank that asked for it in the first place in Q8. And that's why it's important. And it goes against the suggestion that it is completely necessary now for the bank to have a do-over and suggest that the originals need to come back and need to be asked again, because that's not what they wanted at the beginning. They just didn't like the result. So where does this take us? It's not just a couple of lines from a couple of experts in Q8 who are of questionable reputation. This is what the bank wanted. This is what the bank got. These are the experts that have reported on. This is what I would use. Do we need to go into Part 7? More than that? Well, the bank hasn't got anything. It hasn't produced anything. Part 7 requires it to produce, by way of the in disclosure rules, produce the documents it relies on. It hasn't been able to identify it. It can't identify it. It's simply not there, Your Honour. And the disclosure exercise that my learned friend refers to is from the perspective of what he would like to see and the disclosure in England, where we both practice. But that's not what happens here. So if you haven't got it, Part 7 disclosure is not going to help you. There is no point moving to Part 7. It's 2017, this claim was issued. We need to get on with it. And the best way to get on with it is in my respectful submission, the elegant way that I would seek to do it. I'm not saying I'm elegant, the way that I would seek to do it. And that's to rely precisely on what's happening in Q8, which the bank asked for. And get the declaration. The declaration is required because even today, can't get a straight answer as to what the bank thinks about these guarantees, and it needs finality, and finality is a declaration. The learned friend, as John has pointed out, may say at the end, okay, well, what's the point of your declaration? Why do you need it? I'll deal with that issue when it comes up, but that's an argument for the Part 8 trial. I don't know if I can assist you any further.
All right, thank you, Mr. Osman, Mr. Lyons. I thank you both, and those who've assisted you in assisting me. I will reserve my decision And of course, in the usual way, you'll be told when the court by the registry when that's ready. So thank you, and I thank you, the court staff, and that completes the hearing for today.
Your Honour, we're grateful. Thank you.